This is the second lecture in a series of lectures for Political Science 283, Politics of Crime. We want to pick it up from where we left off last time in discussing now the crime control model versus the due process model, which is a fundamental approach in the way we look at crime control and how best to accomplish whatever those aims might be in trying to control crime. Now, I'm putting it that way because there are various purposes in attempting to control crime and how we view those things, which you've already touched on a bit. So let's talk about the crime control model. It is pretty much what it sounds like. How do we go about repressing crime? And in this model, obviously, the approach they take is that it's most important for the criminal justice system to control crime if there's to be a free society. Now, we've touched on that before, but this is one of the key concerns, key principles of this particular model. There's a few others. One is that criminal justice really needs to concentrate its efforts on vindicating victims rather than protecting defendants' rights. Now, that's a critical thing, because in the Constitution, and that's why there's due process model, really the concern, the accent is on protecting those that have been accused of crimes, that their rights are critical. In this model, it's really about the victim's rights. So in the two models, it's the victim's rights versus the defendant's rights. And that's no small difference because what we focus on can really determine the structure of the system we put in place. Another important concept here is that police powers need to be expanded so that we can more easily investigate and seize, convict, search, do all the things that are necessary to prosecute what we perceive as criminals. Also, that legal technicalities that really restrain the police, should be eliminated. You can see there's a very get the criminal sort of mindset here, that we're going to focus on everything that will aid us in accomplishing that, and we're not going to focus on the rights of those that we seek in terms of criminal investigations and the like. So these legal technicalities, if you want to call them technicalities, are obviously important to address. Also, in this model, the criminal justice system really needs to act very efficiently. Step A to step B to step C, and that cases should move along that process in a very quick and clear manner, almost like an assembly line, if you will. All right, so in this model, if the police end up making an arrest and the prosecutor, files criminal charges, the accused should be presumed guilty because the fact-finding of the police and the prosecutors is highly reliable. Now, this is really important. We're saying that it's up to the person that has been charged with the crime to prove they did not do it. That's a very different axis and focus than it is when we talk about due process, where you have to make your case the person or persons or group did it. And you have to convince the court that your evidence is reliable and good. In this model, it's just the opposite. We presume that the police and everyone else has done their job, and therefore the person really is guilty, and now you have to convince us that the evidence the police have and something along those lines, the process is incorrect, that in fact you did not commit the crime. Now, that's no small matter. You really have to think in terms of how one goes about accomplishing that. How do you go about proving something that didn't happen, if that makes any sense? Do we understand that if someone didn't do something, how do you go about showing that, hey, I didn't do this? How do you prove the non-existence of something? right? If I said that, we think that you robbed that store and we've done our job and we have this evidence. Now, prove to us the evidence is inaccurate and that in fact you didn't do this. Well, that's a different task and a much higher bar has been set for proving one's innocence. So again, it depends upon whether the accent is going to be on the accused to demonstrate they did not do it, or whether it's up to those that are doing the accusing to demonstrate that in fact they did do it. Now, there's an argument to be made here that if the evidence is so reliable, then there shouldn't be on the defendant's part a way to really mount a viable, convincing case. So, in a sense, even if we're not talking about this particular model, under the due process model, we end up in the same place, which is if the police, the presumption is that the authorities have got a good case and that they can convince a jury of this. And then it's up to, of course, the defendant to shoot holes in that case to convince the jury they did not do it. All right, so the accent here is very different and it has a very different feel to it and different standards that need to be met. And so here, when we talk about the component parts thus far of this model, you can see the accent in the crime control model is very much focused on presuming or presumptions that we've got the right person. Okay, even the idea that the system should act in a very efficient, almost, business-like manner, point A to point B to point C, that should be like an assembly line, is sort of gives the sense that perhaps this approach has its weaknesses in terms that if the focus is on moving things through each phase rather than making sure each phase is doing exactly what it needs to do, that changes things a bit in terms of, again, the rights of individuals and what kind of an emphasis we place on those rights. All right, so again, the presumption here is that the police and everyone else in their fact-finding has done a highly reliable job, and so this person is guilty. And the last piece of this, the main objective of this approach is to discover the truth or to establish some sort of factual guilt of the accused. In other words, the idea is still to get at the truth, but we're more concerned about demonstrating that there's a high probability that this person did it. Now, when you compare that to the due process model that is presented, we get just the exact opposite of the crime control model. All right, here, the most important function of the system, the criminal justice system, is that due process or fundamental fairness should be the focus under law. Now, one would presume that even under the other model, that fairness would be embraced. But here again, when the focus is on you proving your innocence, it's a little bit harder to make sure that that process has been fair all the way down the line. So here in this system, underneath due process of criminal justice, it's about the defendant's rights, right? Not the victim's rights. Why? Well, the Bill of Rights, and we'll go over the particular amendments, but the Bill of Rights really focuses on protecting the defendant's rights. And why is this? Because typically the defendant doesn't have the resources that the state does to carry out effectively their own defense. So if the resources are limited, then the defense that could be mounted is not going to be as effective as it might otherwise be. Plus, the sheer power that the state has against the individual is so much greater. The sheer force of it is so much greater that even a citizen with that's reasonably well resourced is going to find difficulty in defending themselves against a much larger and dominant force. Now, this doesn't hold true actually in terms of corporations and those individuals with really, really large sums of money in the billions of dollars because they can mount a defense without those protections that would challenge that of the state. Because the state has many different cases, many different foci of their resources, and so they can't match every well-heeled individual's resources as they throw them in to defend themselves, throw them into the system. But for the most part, we're really talking about in the Bill of Rights defending those that can't defend themselves, or certainly don't have the resources to do so effectively. We're trying to protect the least amongst us, the least amount of resources. And here in this model, of course, police powers, the idea is that those police powers should be limited, right? And they should be limited in that they should be preventing oppression of an individual that's been charged with a crime, right? And in this model, the due process model, the approach here isn't that, the Constitution is, well, just a series of suggestions or quasi, responsibilities on the part of the criminal justice system, that these are real, right? And that the criminal justice authorities have to be accountable to those rules. They have to show that they have been consistent with those rules and the procedures involved and the guidelines that have been set up, because those have been set up really to make sure that there's a measure of fairness. And of course, fairness implies that everyone gets that same process, right? It's not fair if somebody that is wealthy gets a different process than someone who is not, right? Everyone gets the same process. So the idea here is that in this system, in the due process system, really it's up to those that are prosecuting to overcome all the obstacles, the hurt, and clear the hurdles that are put in place. The series of difficulties, impediments, restrictions that are put in the system through these safeguards, these due process procedural safeguards that are there to protect people that are innocent, right? But it still allows, obviously, for those that are guilty, there's enough, evidence against them, it allows for them to be convicted anyway. And finally here, you can hold, and this is an odd one, I think, in the due process model, is just because the government has a lot of facts, quote unquote, you can't hold that person guilty based only on those facts. Now that sounds odd, right? You've got facts, evidence, but you have to understand that a fact is not always a fact. Evidence is not always evidence of someone's guilt. In other words, how facts are presented, the context in which they are presented, can determine, in the minds of juries that a person is guilty when that may not be the case at all. For example, if I said in a class that a certain group of people, choose whatever group you'd like, should not be allowed to hold jobs, right? Now, I said that. But if I said that in the context of a classroom to challenge students to think about why that's wrong, it's a whole different fact. Now, if asked on the stand if I said that, and not given the opportunity to explain the context, my answer would have to be, yes, I did say that. And a jury hearing that would say, wow, this person said that. And that is a fact. But it's a fact taken out of context. And so that fact isn't exactly a fact, at least not as a basis for finding me guilty of having said that in the way, right, that the prosecution is using that fact. Right? So a fact isn't always a fact. And some facts, may be true and may be applicable, but they're not. There are exceptions to it, or there are, extenuating circumstances, or there's something about that fact that is not as strong or accurate as one might be led to believe. in the adversarial system of prosecutor and defense attorney, what we have is we have each of those people, those attorneys, holding each other accountable for representing the facts correctly and making sure that the fact is in fact a fact, right? So, all right, so if we want to evaluate these two models, the crime control, which accents giving, the prosecutorial side of things more power and authority, or the due process model, which gives more rights and preserves the rights of the defendant. If we want to compare these two models, can we say that one of these models is a better model? You have to make a judgment, right? And that judgment, oddly enough, can't really be made based upon any nice, neat little formula. You have to decide where you want the accent. As I like to say, which syllable is the accent on, right? That determines your entire approach and the structure of things. Now, if I had to categorize these, and I think this is an apt and an appropriate categorization of these things, the crime control model really reflects in America what our conservative values are. And keep in mind that conservative means different things in different countries, but here it means a group or individual that wants to keep government out of things, and wants to basically have very clear lines that really protect the government and the people. It makes certain presumptions about how the society should move forward, what kinds of values the society should hold, and the like. Due process model does the same thing, only it's more associated with liberal ideas, liberal values. And if I had to look for one thing that defines those, the difference between those conservative values and those liberal values, is that the accent in one, the liberal, is more about the individual, and on the conservative side, it's more about the state. Which indirectly affects, obviously, the people themselves. So what happens here is something very interesting. We go back and forth between those models, which adds another level of complication here. One person found guilty during a time when one model is dominant may not have been found guilty at another time where the alternative model might have been dominant. So even that part of the system, that moment in time, really can change, how we view things, how we determine what is right, what is wrong. I mean, all you need to do is look at the Supreme Court and look at the number of times they have reversed themselves, and you begin to get a reasonably clear understanding that this all isn't written in stone. Now, I'm not going to bother to go through the history of, the process moving forward, going back and forth between these two systems. So the idea here is to look at the structure of that criminal justice system, right? The way in which it operates and the like, and not necessarily go back and look at the history and the number of times we've gone from one of the models, the due process model, and back and forth. That's not what we're really interested in doing here. At least I'm not interested in doing here. So when we look at the structure of criminal justice, right, we have to first define what that really means. What does the structure mean? So basically what we're talking about here, when we talk about the structure, we're talking about government structure, right, and a collaboration and a aggregation of federal, state, and local laws that come from legislative bodies, that come from the executives, the governor of a state, and president of the United States, all that sort of thing. Even the agencies that might deal with a particular area of governance. So each of these then process what? Suspects, defendants, convicted offenders, and the like. In other words, there's a whole process there, right? So the system, right, that's put in place, as we've talked about before, the fundamental framework, not all the little nuts and bolts, not all the pieces, that's done on the application level. That's done on the execution level. How those things are executed, as we talked about before, it kind of determines really what that law is as written by the legislative bodies. So the basic framework of the law is put in place obviously by legislative bodies, and it's dealt with by judicial bodies, and it's also prosecuted and moved forward by the executive branches of government. That means the governor on the state level. It could be the mayor. It could be the president of the United States. So there are players in that structure. Now, I would argue that the most important is the source of the law, where these things begin, before they get interpreted and the like. And that's the legislature. Why? On the state and federal level, that's where the crime, the structure of it, gets defined, where they determine this is a crime. This is a crime. And they define what that crime is. Now, how they determine something's a crime is often subject to a moment in time. There are some that, are not subject to that necessarily. In other words, murdering another individual has always been a crime. Where that's changed over time is what part of that process in terms of committing that crime, someone might have been involved and what was their role. For example, someone that discusses with someone the likelihood of robbing a bank, and that would be a good idea, but they never reach a point of determination that they're going to do it. Just that would be a good idea. There's a lot of money there. And then one of those two people doesn't go any further with it, but the other person does. They rob the bank. Now, because the conversation took place with the first person, does that mean that first person, that first individual, is implicated in or part of that crime, right, in committing it? Well, rules of evidence, structure of how the crime is defined, because the legislature can say anyone that's even spoken about the possibility with another person of doing and committing a criminal act is in fact, or has in fact implicated themselves in that crime and is held equally responsible as the person that executes that crime. They could write that, but there's other processes in place, including the judiciary, which we'll get to in a minute. So the legislative bodies are very powerful here. They define what's a crime, what's not. They can associate, fix, structure sentences that go with that crime. And they can also then, this is important, people often I think forget this, they can provide the funding for the agencies that are involved in carrying this out. So for example, if the FBI does not receive enough in its budget to execute the number of laws that the legislative body has written, then the FBI has to make a determination about where they're going to place their limited resources. So the legislative body, oddly enough, can write a law, want it enforced, and then the very agencies who would be responsible for enforcing it are not given the budget to be able to enforce it effectively. Another example is the IRS. The IRS has a mandate to collect all of this money, but doesn't have the budget and therefore the personnel to actually do that in any real effective way. And that's really problematic because what you're doing is the legislative body is writing a law that demands that these agencies execute those laws fully. But then the same legislative body in their budget does not allow for the individual, manpower, the money for everything from tape recorders, to all kinds of electronic devices, so that the law enforcement agencies can gather information. In other words, you can write the law, but it can't be executed if you don't give the resources or the means for the resources necessary to carry out and implement the law you've written. I know it sounds very odd, but it happens all the time because in the minds of legislative bodies, especially Congress, they don't really look at those two pieces together necessarily. They see it's good to write this legislation that limits this crime, and then they go on to a budget bill, and they think, well, we've got to cut some money out of the budget, and we would like our money to go here, to this constituency, or here to this other program. And although they've written a law that's going to require more resources to execute, they have now put a stranglehold on the agency that is responsible for carrying that out. And that also makes the agency very susceptible to criticism and criticism on the part of the legislative body. So here it's interesting. Legislative body writes the law. They tell an agency that you must execute the law. And then they tell the agency, but we're not going to give you enough money to execute the law. And then when you don't, we're going to accuse you of not executing the law. And the fact that you did not execute the law is a fact. So this goes back to our issue about facts, right? It's a fact. You didn't do it. You take that out of context, and you don't have an opportunity to explain that, well, we did implement it, but we were not given the resources by this Congress or by this state assembly or state senate to carry that out because we needed X amount of resources and our budget was cut. So we were given more responsibility and more work to do, but with less resources to do it. And prior to the budget even being discussed, we were already maxed out in terms of, a resource allocation. So you can see how a fact is not a fact. You can see how, even though the legislative body is so powerful, that they can actually work against their own ends, which seems odd, I know, but legislative bodies on the state, local, and federal level do this all the time. So there's an important player here then, given that reality, and that's the judiciary, trial courts, and the like. What are trial courts supposed to do? They're supposed to adjudicate. They're supposed to hear the facts and make a determination, right? On a whole host of things, but the most important of which is the guilt of that individual charged with a crime. That's what trial court does. It's a trier of fact. Show us the facts, we'll make a determination about innocence or guilt. Now, once a charge has been a crime has been charged, then that guilt has to be established. Regardless of which model you're in, we have to establish that that person committed that crime or what have you. Then there's the appellate courts, and they're going to interpret the law. They're not necessarily concerned about the facts. Those have been established. The facts do come in terms of how they've been used and what facts were allowed in and what facts were not allowed in, because there are rules of evidence. What should be allowed in as evidence and what should not be allowed in as evidence. And that's important because it helps level that playing field. So the appellate courts then, they interpret the law, and they'll interpret it according to what the constitutional principles are. In finding this person guilty, did the trial court in any way through its processes, right? For example, allowing certain evidence in they should not have, or what have you, did they through their processes violate some sort of constitutional protection? So you get that under the due process model, right? All right. And this is true, by the way, of state and federal appellate courts, right? They're going to actually review not only what happened at trial, not the facts, but what happened at trial, and juxtapose that against constitutional principles, but also the legislative decisions that were made and whether those fall within appropriate, constitutional or state law or federal law boundaries. In other words, the appellate court is interested in two things. Hey, what happened in that trial? And was what happened okay? It's acceptable. And also, let's look at the law that person was found guilty of violating, and let's make sure that law, this is what the appellate court's doing, falls within the same boundaries. Doesn't violate the state law, right? Doesn't violate federal law. And of course, the ultimate law, the law that all must conform to, is the United States Constitution. Has there been a constitutional violation here? So judicial review allows those courts then to evaluate the process itself and the legislation that was put together in terms of, do those things conform to the Constitution? If a law ultimately conflicts with the Constitution, then the appellate court can may be able to strike down that law. That doesn't mean the Congress or the legislative body can't write another law. They would have to, that does the same thing. But now, given the information based on the determination of the appellate court, those legislative bodies now can write a new law that will affect their ends, that will not have the inherent weaknesses, at least as the court has defined them, right? Those inherent weaknesses that the first piece of legislation had. In other words, here's the law. The court says you can't write that law that way. And then the legislative body gets it back, and they go ahead and rewrite it so that the objection of the court is taken into account. Right? So both state and federal appellate courts, they're going to review legislative decisions. And again, decide if they fall within those boundaries. And of course, we're all guaranteed that one appeal. There's no guarantee that we can then appeal the appeal. In other words, not everybody's going to get their day before the Supreme Court. That we're entitled to that one appeal as an absolute. And then whether or not we can appeal the appeal comes down to whether or not the Supreme Court is willing to take on that case. So there again, it's a determination made by the court. The person may in fact have not committed the crime, because perhaps the way the legislation was written is problematic, or the way the process took place is problematic, and that might have not, although grappled with it, might not have been clear to the appellate court that that was in fact the case. But that person goes to jail, let's say, and another case, similar facts, but maybe just a small difference, and the appellate court picks that up, and you have a whole different outcome. Or the appellate court doesn't pick it up, but it makes it to the Supreme Court for any number of reasons, including the Supreme Court feels like the law as written is very confusing, or there's a complication in that some appellate courts are deciding that this law means X, and other appellate courts are deciding this law means Y, and we need to get on the same page. So the Supreme Court's going to take it and clarify that it belongs on page X or Y, and oftentimes that it belongs on page Z. In other words, they don't agree with either appellate court decision, and they're taking the case to sort of clear this up. So moving forward, everyone sort of knows exactly what the rules are and what those rules embody. Okay, moving forward, and I hope that you have a better grasp of exactly, what the issues are. I haven't covered the issues in a way that's, completely comprehensive. In other words, that sort of sounds redundant, but it's impossible to cover all the machinations here, all the various ways in which this all works. But I want to make it clear to you that this is not, the law is not a lookup table. This is not something that's a science. It can't be. It involves human beings, human nature, and human actions. And those are unpredictable and varied. And so it's very difficult to get our minds around some sort of structure that's, going to fit every situation. All right, so beyond the judicial branch, you do have the executive branch, right? And again, it's governors and mayors and the President of the United States. And they have the power. They have power to appoint judges, right? In some cases, some are elected, as we've talked about. Appoint heads of agencies, police chiefs, directors of, departments of correction, the people that are involved in the various processes that make up the criminal justice system, right? Also, elected officials can look to improve that system, right? They have legislative agendas, and they use that bully pulpit. They try and get the people behind their legislative agenda, and thereby hopefully convince the legislators that they need to address these issues. So, okay, what then, as we can see, are the major parts of this justice system, right? What are the major structures within it? Organizations and the like. Well, obviously, on the ground, it's the police. And then, of course, it's the courts. And then there's the structure of the corrections system, right? And basically, the purpose here is obviously to address the issue of crime, the violation of the rules that have been set up by Congress, whether those violations, prove to be felonies or misdemeanors or what have you. It doesn't matter. That's the structure. So keep in mind that police departments are public agencies, right? And their job, no matter how you perceive it, is to maintain order. And beyond that, they have to enforce the law. And also, they provide services. Some sort of noise, excessive noise is occurring in a party next door. It's a simple service, right? The police come, knock on the door, and say, "Hey, it's after 10 o'clock at night. You're going to have to, lower the volume here." And of course, the police are, directly tied to prosecutors and criminal investigations, right? They're the primary source of gathering evidence, right? And you need that in order to convict someone in court, right? And so are the courts. These are really places where people come to be heard, right? They're tribunals, and basically their criminal liability or culpability is determined by judges or juries after hearing the facts. Hopefully, there's a just and accurate and fair representation of those facts. Okay, so the idea of the courts then is to basically get at the truth, because if you can get at the truth, then justice will be served, right? So the fundamental players, obviously, are going to be the prosecutors on the one side, the defense attorneys on the other, and the judges. Of course, also coming into play would be juries and the like, if there are in fact juries in that matter. What about the corrections part of this system, right? Well, that includes things like jails, prisons, probation, parole, whatever the sanctions are that are seemed appropriate given the facts in the case. It could be anything. It could be house arrest, for example. These sanctions. It could be electronic monitoring. So the idea here is that the correctional piece of this, they're not just there to punish people. They're supposed to be rehabilitating them, and in so doing, help ensure the public safety. Now, keep in mind, and I've mentioned this before, this is a little misleading, because once you've been found guilty of a crime, that becomes public record. And once you've been, quote unquote, rehabilitated, that doesn't go away, that record, right? If you've been granted parole, it doesn't go away. Certain crimes, not only does it not go away, but people are notified that you've violated the law. In the case of child molestation, that sort of thing, there's a national website you go on to find out if anyone in your neighborhood was ever, found guilty of a crime against a child. And so, given those circumstances, and I'm not making any judgments here about whether we should do this or not, put together a database and track people, what have you. I'm just trying to point out that the system itself has consequences. Now, let's look at just the person that committed a crime. They're 19 or 17 and maybe charged as an adult, and they rob a liquor store. They're found guilty. There's no real weapon involved. What I mean by no real weapon, the person feigned having a gun but didn't. Let's say that's the factor that is driving what I'm about to say. And they go to prison, and they serve 6 months, let's say, or a year, or 2 years, which is a better period of time for what I'm about to say. And that now is a criminal record. They apply for any job. There it is. It's part of the public record. Right? Now, how do you explain to a prospective employer that you were arrested for robbing a convenience store, and you served some time, but you're a model citizen, that you've been rehabilitated? They don't care about the rehabilitation, right? That employer is thinking, you've committed a crime once, you might do it again, or they might be thinking, you're not going to do it again, but it says something about who you are and your character, so you don't get the job. And then you don't get the next job, nor the job after that. Now, you need to be able to support yourself, and if you have a family, help at least support your family. But no one's going to hire you. So what are your options? You need to eat. And therefore, it's not uncommon for people that are placed in that position to do something that violates the law. And then that cycle begins again. So the idea of rehabilitating people, while you might be successful in doing that, the world that they're going to enter when they get out doesn't really put a lot of value in their being or having been rehabilitated. And so once found guilty, they're guilty for life. In a sense, every criminal act gets every criminal found guilty gets a life sentence. Maybe not behind bars, but certainly within their own lives, trying to get their lives back on track and the like. Unless you've got someone that's really willing to go out there and hire ex-convicts. Now, we know this in the criminal justice system. Why? Because if it's not someone tried as an adult, the record will be sealed. In other words, no one will know that this crime took place. We make the presumption that someone that's underage is not acting in a way that demonstrates they have the capacity to really think this through. The frontal lobe of the human brain is where reason and rationality sort of reside. But we know that doesn't fully develop until around the age of 25 or after at some point. But here we have someone who's 17 in the first scenario who's been found guilty. Someone who's 16, maybe by a day. That's it. Their record is sealed. So based on that one day, one person has a conviction following them for the rest of their lives, and the other doesn't. Now, legislators recognize that this is the reality. But the idea that we can put in place in a criminal justice system that once you've served your time, you have a record that people have access to, that system can anyway rehabilitate people, well, that's just, that's just not looking at anything that's real. It's not based in reality of any kind. And so rehabilitation is a nice thing to talk about. It makes the society seem less punitive, but at the end of the day, the person has a record, right? And there's not much you can really do about that. All right, let's look at the differences then between the federal and state systems, because they don't have to necessarily act in the same manner, be structured in the same manner. Now, keep in mind, if there is a difference between federal and the state systems, that means you could have 50 different, because there are 50 states, different state processes or structures. And so there's a lot of play in the way in which states operate. So not only are there differences between the federal and the state systems, but there are differences between the different state systems. And so there you have it again. If you have the misfortune of committing a crime in one state, say murder, you might be executed. If you are guilty of a murder in another state, it might be imprisonment for life without the chance of parole. Now, you can make the argument that in some ways being locked up the rest of your life is worse than being executed. That's not an issue we really want to deal with because we don't really know the answer to that, right? In other words, we can speculate, but I'm sure there are those that would rather be executed than spend the rest of their life in prison, and I'm sure there are those who would rather spend the rest of their life in prison rather than be executed. But the differences in the state laws can determine something like life or death for exactly the same crime. For exactly the same crime. Now, let me give you a ludicrous example. A crime is being committed on the border of Texas, let's say, and another state. And on one side of the state line is somebody holding the victim's right arm, and on the Texas side, the other person is holding the victim's left, arm. And basically, they're beating the guy to death. Okay, well, the crime wasn't committed in the same state. Texas does not have jurisdiction over the person standing in the other state. Now, I know that's ridiculous. I mean, we're talking, although there are 4 states out west, right, that share the same border. But technically, that could happen. Right? Technically, that could happen, although because the crime involved 2 states, it would become a federal issue. But nevertheless, you get the point. All right. So basically, the federal and state systems, they're going to carry out the same functions, right? They're not doing anything different in terms of what their structures are. What has to be in place. There's prosecutors on the federal level and on the state level, for example. But the laws and the agencies within those 2 systems differ, right? The legislators, right, make most of the criminal laws, and those criminal laws are enforced by state and local police. And then you've got the city and county prosecutors, right, that go after people that have been accused of breaking state laws, and they're in state court. And judges convict those of violating the state laws to serve time, either in local jails or some sort of state correctional facility. While on the federal level, Congress is enacting criminal laws, and the federal law enforcement agencies, like as I mentioned before, the FBI and the U.S. Attorney's Office in general, they prosecute persons accused of committing federal crimes. Right? And U.S. courts try those cases. So those things, the U.S. courts and federal courts and the state courts and the various agencies, they are not moving in lockstep. They are not one and the same thing. They vary greatly. Okay, let's talk about then, break this down. What's that first line of defense in the process, right? Keep in mind that a lot of justice is administered on, mostly on the state and local level, because most of it involves a state or local piece of legislation, right? And it's the state and local governments that employ the vast majority of workers in the system, right? It's not the federal government. And of course, the states bear a greater part of that burden in terms of the costs of that process, right? The resources needed to be expended in order to create that system and keep that system intact. And then you get the same thing with the state, the county, city criminal justice systems. They can vary. So you've got a mess of criminal justice systems here. You've got the federal level, the various state levels, the city levels, the local levels, and all of them are writing laws, and all of them are treating these things somewhat differently, right? So one thing we can say about state, county, and city laws, they're really protecting people from the kinds of crimes that we all read about or hear about every day. Thieves, stealing, right? Rape, murder, that sort of thing. They're dealing with the crimes that we as a general public, when asked what's a crime, probably, pretty much default to, right? If I asked you to think of another type of crime besides stealing, raping, or murder, you might come up with a few, and there's many, but typically that's how we think of this when we sort of read the headlines. So the question is, with that many players involved doing that many different things, although the fundamentals are there, can we really say there's even a system at all? So some people say, some scholars and some critics of the system will say it's not a system, right? The criminal justice system, its agencies are independent bodies. They're executing things differently. And they get their authority from different parts of the government, state, local, federal. And as I've touched on before, their budgets come from different sources often. So you've got the legislative bodies writing a law. Budgets may or may not come from that body, but from another, right? And their authority comes yet from a third. So we don't have a criminal justice system, I would argue. So I'm in agreement. In terms of, on every level, everyone's moving in lockstep. That's not the case. And so we have to keep that in mind. Typically, when you talk about, for example, police departments, it's towns and cities, right? But prosecutors, defenders, public defenders, trial courts, and jails, they're usually countywide. And you get statewide, like prisons and appellate courts, that are statewide. So you got the state and you got the federal, you got the state, you got the localities, towns, counties themselves, all with different pieces of this. In fact, in New York State, if you're found guilty of, let's just say, a traffic violation, you go to court and you fight it. Even if they reduce the fine, when you go to pay that fine, all of a sudden there's more money tacked on. Well, in the configuration of things in New York State, the police officers that work, for example, in New York City, are considered state workers, and they are on loan to the city. And so, whenever they, stop crime or, help find someone guilty of a misdemeanor, the state says, "Well, we loan them to you, so we want a piece of that." So the penalty goes up because the state gets a piece of that no matter what the court determines. If there's a penalty involved, you can reduce the penalty, but that reduction is not going to us. It's going to the locality because you're really using our police force. Most people don't know that the New York City police force is really not the New York City police force, but a state police force on loan to the city of New York. So you get all kinds of different scenarios here. And to make matters more complicated, these agencies in their varied forms don't necessarily coordinate one with the other. So what they decide in one agency may not be accounted for in another. I mean, at times, if you look at this closely, it's sort of amazing we even have a system that's intact at all. All right, so what about the role of citizens now in this process, right? Well, as I said, the idea of the criminal justice system is to really preserve the rights of those law-abiding citizens. So we have to somehow have this balance. We have to be willing to give up some of our freedoms in order to get the order we need to have that, those freedoms. In other words, if everybody is totally free to do whatever they want at any point, then no one is really free. Because the most important thing about freedom is that you should be able to focus on things that benefit your life, that increase the value of your life, that make your life more enjoyable for yourself. Not focus on things that prevent others from taking away, really what it comes down to is life, liberty, and property, because they've decided to do that. So oddly enough, in order to keep our freedoms in place, we have to be willing to sacrifice some of our freedoms. So that's the criminal justice system as a part of that. I always say, as do others, that your rights end where mine begin. Otherwise, we don't really have a free society. We have a society where it's every person for themselves, and those that have the greatest number of resources and numbers, in terms of people that are affiliated, tend to win the day. That's not freedom at all, right? So that means there's always these competing democratic values, right, in that struggle. What's more important? Is it order in this case? Do we want to make an example of this person? Or are we going to focus on freedom and, adjudicate this in a way that demonstrates that, you can't operate this way and take away someone's freedom based on those operations? So the state, the federal government, the entire criminal justice system has to make peace with that, has to deal with those competing values in a way that makes sense. And it's constant and it's ongoing, right? That conflict between, crime control on the one hand, and on the other, providing due process so that that system is fair, because we're going to take away someone's life, liberty, and property if found guilty, right? That somehow has to work within a justice, a justice system that is going to produce what the citizens are willing to embrace in such a way that they are willing to forego some freedoms because of that system being in place and its value, and take on certain responsibilities. So give up some freedoms, right, in order to get the freedom, the majority of freedoms that they wish to have. So citizens are an important part of the criminal justice system. There's many different roles, not just victim or criminal, not just those two roles they play, but they influence legislation, right? They can lobby elected officials for changes. Citizens can influence the judicial policy-making structure as it is in place, right? There are some that obviously have a greater voice than others. I mean, poor people, and typically in America, even to this day, racial minorities, they actually can influence more in the court system, right, than they can over legislation. Let me explain that. Legislation often is influenced more effectively and to a greater extent by those that are in the upper classes who have the resources that they can, offer to legislators running for office to influence them. They can also afford to pay for lobbyists, people that, have an office down on K Street in Washington or up in the state capitol, who are lobbying Congress people to vote one or another way on a bill. In some cases, these organizations write the bill, and the person in the legislature just, endorses it or brings it into the chamber, right? So poor people, on the other hand, don't have those resources. But by having the cases come to the courts, they can actually influence that legislation in terms of whether or not it's consistent with the law and viable. I'll give you an example of this. The NAACP, when Thurgood Marshall was heading it, who later became a Supreme Court justice, he understood that trying to influence legislation was a costly, drawn-out process that would meet with a great deal of resistance from those who did not see an advantage in advancing the rights of African Americans, or back then colored people, right? Okay, so his idea was, look, we can win the day in the courts. We expend less resources. We're not going to have anyone else really fighting us on the other side except for the other attorney, right? The other party involved, usually the state. He was also wise enough to understand that the court takes time to sort of change direction. So that would mean that they'd have to bring a couple of cases before the court where they would have to soften the court up a bit, if I can express it that way. In other words, where they could make some fundamental arguments the court would hear and the court would have to think about. In other words, set them up, the court, in a good way, to hear a case that might just win the day. That case came along. It was Brown versus the Board of Education. There were other cases before that had moved the court in the direction of segregation being incorrect. But Marshall understood that if they could win the day with Brown versus the Board of Education, the Plessy versus Ferguson case, which established the rule of separate but equal, would be struck down. It would be removed, in a sense, by the new precedent set by Brown versus the Board of Education. So he understood the access of those without resources into the system is through the judicial system. Now, that is not to say that that's a process without a great deal of cost. It does cost a great deal. But there are organizations that can represent poorer folk, those that are less resource rich, and can do that effectively and deal with those costs. So basically, when you look at legislative bodies, they're more prone or more likely to hear the voices of the upper classes around policy, where you are going to have the courts probably more sensitive to those that aren't well resourced, as I said before. Also, you have public interest groups, right? Their job is they want to raise the public awareness, the consciousness of the public and the elected officials about criminal justice issues or matters. So the National Organization for Women example now, right? It's made people aware of the problem surrounding battered women, and has managed to get policies changed that make domestic violence a crime rather than just a family matter, right? That it's not something that just happens in the family, but it's a crime to beat another human being, in a way that causes, harm. Now, let me clarify that. It sounds like I'm saying it's okay to beat people. No, but obviously the court is not going to adjudicate a case because somebody, no matter how inappropriate it is or was, slaps somebody else, and that's the full extent of the interaction. Now, I'm not saying that's right. I'm not saying that's acceptable. What I'm saying is, given the horrors that can take place, the court's probably not going to put its resources into adjudicating that matter, and that's probably a family court matter. Go to family court, work that out, seek counseling, that sort of thing. Or MADD, Mothers Against Drunk Driving, people that have lost children to drunk drivers. They've succeeded in getting, during certain times of the year when the number of people drinking and driving goes up, around the holidays, that sort of thing, to get the police out there at certain points, checkpoints, and stop people to see if they've been drinking or if they are above the legal limit. So you can influence, and these public interest groups can raise public awareness about what's going on out there. So the citizen, as part of these organizations, also has a great deal of influence. Another way is performing jury duty. Now, for most Americans, the goal around jury duty is how to get out of doing it, and I understand that. Giving your time over to that process and the like can be, can infringe upon someone's, day-to-day life. But nevertheless, you're a citizen of a country. You have to have a certain responsibility or certain responsibilities in order to keep that system moving forward in an appropriate manner. And I think that people think of people that, a jury duty is something that someone else should do. It's not exactly the same as, but the thinking is, a close cousin to those that say, why vote? My vote doesn't count. And my response to that is, okay, so would you like your vote to count more than everybody else? In other words, should we create public policy simply around your vote? Bob or Alice is voted, and this is what they said, so we're going to do it. Would you really want that kind of responsibility? The idea of a vote is it's a drop of water in a bucket, and that may lead to you having a greater voice, because if you join those that voted for the same candidate you did, now that person gets elected. So you go from being one voice out of, say, a million to really one voice out of, let's say it's the Senate of the United States, out of 100. So that's a pretty good, that's a pretty, good improvement in the odds, right? So you're voting really to get representation. And it's that representative that carries more clout because you trust them to look at those issues, and while you get on with your life, focus on those issues. I'm not going to get into whether or not the system works or whether we're really represented by those people, but that's the idea behind voting. Behind jury duty, you're really protecting yourself. As a jury, you have to find innocence or guilt, culpability or not, right? And that means by you getting involved in that system, you're keeping that system moving along in a way that it should, which is, and now I'm sort of showing my hand here, in the due process approach, right? Protecting people. Is it better to let one guilty person go because you couldn't find enough evidence against them than it is to put one innocent person behind bars? I mean, this is a personal conversation you have with yourself, right? What do you weigh more? For example, before there was DNA science, people were executed because they were found guilty of committing a crime. As we've gone back now with DNA science and looked at, many of those cases where there was, where we could have used DNA, technology if we had it at the time, what we found is that in a great number of cases, almost 50%, the people that were executed were innocent. Do we really want to risk that? So being part of the jury system, being part of the voting public is key in protecting your own rights. Just because you're not your life is not on the line doesn't mean that one day it won't be, or that your children, or that your neighbor, or your friend, or that just the tenor of the society changes because, the public has turned a blind eye to all this, and now there are political wills at work that are seeking benefit for themselves, maybe at your expense. So bringing in the values of the broader community, is very powerful. Believe it or not, it also interjects into the system, or injects rather into the system, some common sense. What does the person on the street think? Now, you may not like what the person on the street thinks, so you may think the person on the street is woefully informed, and I wouldn't necessarily disagree with that, but nevertheless, there is an exchange that takes place there, right? You have a right to bring your opinion to the public, whether they like it or not. Another role of citizens, obviously, is reporting crimes. and testify in criminal cases to what they saw or what went on. So in many ways, the police depend upon average citizens, to give them some insight, some evidence, or some clue as to what's going on. Someone escapes from a prison, they send out the picture. What's going on? Have you seen these people, this person? Help us out here. Or in the case of a lost child, where a child has disappeared, and the public is made aware that this child is missing. And there's an Amber Alert. And people are on the lookout then for some sort of car, or they're given a description of what the child looks like. Now, if you don't have a child, maybe it's difficult to imagine the horrors of turning around and seeing your child not there, and not knowing where they went or what's happened to them, or if they've been taken. It's absolutely, it's mind-searing. The thing that is on the top of the stress spectrum, the thing that we know stresses people out the most, is not losing their job or a divorce or even, a terminal illness. It's the loss of or the death of a child. That is number one on the list. Okay, there are several other things, obviously, that the public is involved in doing. Mediation. There are boards that are set up where cases are resolved through mediation. They're not adversarial. They're designed to save money, allow victims to participate in the justice process, and even reintegrate offenders into the communities, given the caveats I've already spoken about. They also monitor the criminal justice system. Citizens do, people do. There are citizen review boards, right, that are not made up of police officers, right, and assess how the police departments are handling citizen complaints, right. These boards can recommend all kinds of actions, of remedial nature, even disciplining officers. Almost all, well, I shouldn't say almost all, right now about 70%, 70 to 80% of the largest cities in America, they have these civilian review boards, crime commissions and the like. Also, citizens are involved in providing information about, what criminals have done, the harm they've caused, right? A lot of victims of crime have an opportunity, at least, to influence judges and their sentencing decisions, right? Demonstrate that there were aggravating circumstances that might influence the judge to be harsh, or go before parole boards and let them know, look, this person should not be paroled. Here's what they've done. Now, there are some that say, look, having victims come in, or family members of the victim, and testify at the sentencing, part of the process, it's really allowing them to spew their vengeance, right, in a way to drive the sentencing process. Now, we can get into a whole argument about that. I think there's a measure of truth on both sides of that argument, that you want the judge to be aware of the impact this crime has had, but you don't want the, those that have been victimized to necessarily impact the process where the person gets a harsher punishment than they might otherwise have gotten. Now, my particular position on this is that's why there's a judge. A judge should hear it, the impact on the victims, and they should give the person that's been found guilty of the crime an opportunity to speak. But they've been trained, they're judges, they're part of the judicial system. Their responsibility is not really to be swayed by those things, but be informed by them. And there's a major difference between being informed by something or an event rather than being influenced by it. Influence is really about future actions and the way you behave, right? What changes your course in thinking or action. But being informed just gives you a better sense of, okay, what's the weight of this issue? And what's the context in which it must be thought about? So I have more confidence in that part of it, citizen involvement in there. Citizens are also, about civil liberties. Americans are very conscious of their rights. Sometimes they think they have rights, they don't. Like freedom of speech, that they have a right to say anything they want at any time, and that's not really the case. That's where, rights conflict, your rights and my rights. And there are certain things you can say, obviously, because they're going to cause a breach of the peace or the like. So those individual rights are the rights that are guaranteed to people, and the government can't abridge those rights. That's part of the due process structure, right? And often, citizens don't know, what rights they have. But they're going to assert that they're going to assert they have a right to those rights or an entitlement to those rights, and that sort of moves the system along. Another key factor here is that there are, beliefs in specific rights that, a convicted felon, right, might inform the system about, right? The Supreme Court can use a case to actually establish a right or define a right that may not be clearly perceived or even thought of as a right, right? And that decision by the court then can move forward. So, for example, the right to privacy is not mentioned anywhere in the Constitution, but it's actually played a part in thousands and thousands of cases dealing with police procedures and searches and seizures in large part. So it's not mentioned in the Bill of Rights, but the court has determined, a famous case is Gideon versus Wainwright, that if you have a right, do you have a right to, for example, attorney at a felony trial? Well, these are important rights that may not be stated or clearly stated that have to be addressed because someone brought it to the courts. Now the courts have said this is a right, and now the police and everyone else must treat it as such, right? Keep in mind that the main source of citizens' rights in America, right, is the Bill of Rights. Now those are the first 10 amendments to the Constitution. Well, actually, they're the first 8 that deal with that issue. The 9th and 10th are really about states and people, the rights that are retained and the like. These took effect in 1791. The first Congress put these together. They weren't put in place by the Constitution or the Founding Fathers, but that first Congress put them together. It was a very contentious issue as to whether or not there should be a Bill of Rights. A person like Madison flip-flopped on that issue several times. Should there be a Bill of Rights in the Constitution itself, or is that something that should be addressed later on? But there are amendments that we're interested in this course. Because they actually involve directly the criminal justice system and criminal action and how a defendant should be protected. And these amendments, if you had to put them in a category, they depict the procedural rights, that citizens that are accused of a crime have a right to. So that ends this part of Lecture 2, what we're calling Part A. There'll be a Part B, which will not be as long as this, which will cover several other issues, the amendments, and we'll pick it up then.